Right now. All right, so you all heard we're recording today's session. Thanks so much for joining us. I'm Victoria Merritt. I'm one of the associates at Ascent Employment Law. With me is my colleague Jessica Gibson. And Richard Johnson is lurking here to manage the chat and questions. So he'll be moderating the Q&A section. We encourage questions throughout the presentation, and I'll expand on that a bit more in a moment. So welcome to our second employer huddle. I know some of you probably joined us for our January session, and we're already somehow halfway through February. So today's session is Employment Contracts 101. Before we dive into the session, we'd like to acknowledge that we do our work on the unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. So as I mentioned, please ask questions throughout. We get great questions. It encourages great conversations. Richard is here. He'll be moderating the Q&A section, and he'll either answer them directly in the Q&A, depending on their complexity, or he's going to flip them to us to open to the floor as well.
Yeah, please don't hesitate. I will type as fast as I can, but keep those questions coming because this is your opportunity to bounce anything off of us. So I'll attend to that and talk to you very soon.
Yeah, and he's promised otherwise to be a silent participant today, but we'll see. So a little bit about me. Like I said, my name is Victoria. I started my practice out in Alberta at a mid-sized regional firm. I practiced employment law, but I also did municipal professional regulatory work, as well as administrative. And for a brief while, a lot of foreclosures, although that was not my favorite. Municipal work I liked, admin I liked, and employment I obviously really liked, because that's basically what I do now. Fun fact, I live in Squamish, so if my out of office is on and it's not work related, I am probably chasing powder at Whistler, although that's been a bit scarce this season, or I'm trying to get up a mountain in the summertime. And presenting with me today as well is my colleague, Jessica.
Hello, my name is Jessica. So I was called to the bar in Ontario in 2020, and I began practicing in criminal law. Sort of love, didn't love, weird relationship, criminal law. So luckily for me, I had the great fortune of being called to the bar in British Columbia and starting work with Ascent Employment Law in 2021. My main focus areas are employment law, of course, human rights, and I've done a bit of work in disability and charter issues as well. Fun fact about me, to bounce off Victoria, I've been a snowboarder for a long time, but I actually had the privilege of snowboarding in Whistler this past weekend, and we'll be going again this weekend. And despite the lack of powder, perhaps for Whistler residents, I was blown away by Whistler for obvious reasons. The mountains are incredible. So shout out to Whistler.
Amazing. So today, just a bit of an overview of our topic. So we are taking you back to first year contracts law. Very exciting. Congratulations. You're in for some fun stuff. So Jess is going to be reviewing the legal requirements for valid employment contracts, advantages of written contracts, and the interpretation and enforceability of contracts. Now, all of these can get a bit academic, but they're also really important in terms of understanding why we recommend including the provisions we do, and sort of avoiding some of the very practical concerns you can have with employment contracts when it comes to those being contested by employees or any concerns there. I'll then be going into key contractual terms as well as some drafting tips as well at the end. Again, questions throughout are great. We should have time at the end to go through quite a few if we're not addressing them as we go. And with that, I will turn it over to Jess.
Thank you, Victoria. So we're going to begin at the bare basics, which is always a good place to start, as per my contracts professor in first year law school said, and I have found this useful in my own practice. So I'm sure many of you have heard the basic requirements for a contract, but it's always good to start from the beginning. So obviously, three main legal requirements for there to be an enforceable contract. There are obviously other requirements that can fit in here, but the bare basics are for there to be an offer, in this case, an offer of employment. Next is acceptance, would be the employee accepting that offer of employment. And within that, to make this agreement legally binding, we need consideration. So something given or promised in exchange of the employment contract. So obviously, typically that is a salary for work duties. And so we're going to go over the advantages of the plainly written contract. But before we do, Miss Victoria has created a very cool poll, which hopefully you will have access to. And we would like to know, do you, in your opinion, does an employment contract have to be written, in order to be enforceable?
Okay, answers are flying in. I'm super glad this is working.
Yay.
I thought it might be beyond my tech capabilities, but
Clearly not. Well within.
smooth. So we'll give one more minute to get the last few answers in. And poll, share results. You see those up on your screen there. So mixed. So half yes and half no. So
Good. Yeah. So thank you for your answers. Just so you know, we go to, well, before the reveal, yes. So actually, oral contracts are just as enforceable as written contracts, oral or handshake contracts, as they are called. But there are some great disadvantages to oral contracts. They can create a lot of fuzzy gray area and a lot of debate back and forth if there isn't something written down for people to refer to. So, for example, it's harder for both parties, employer and employee, to prove its terms. If, when the employment relationship was initiated and certain terms were put in place and agreed to, a few years later, if one of these terms were to come into question, it's difficult to say, after a certain period of time, maybe people eventually disagree or misremember what those terms were. And then unfortunately, if this dispute were to be taken to court, the court themselves may impose a term that wasn't even there in the first place. So depending on what the court perceives the parties' intentions were in regard to the disputed term or terms, they may decide, actually, this is going to be the new term. And so that's a huge disadvantage of an oral contract, is that you might have some random third party in the form of a judge deciding what your employment contract is. So another huge disadvantage is that when you agree things through just a handshake or oral terms, you may miss some really important aspects of the agreement. At least from our perspective, looking at employment contracts for employees and employers and drafting them for various businesses, there's a lot of terms that are considered going into those contracts. We like to try and prepare for any sort of situation that can conceivably come up. Obviously not to, great exhaustive lengths, but it's definitely better to be over than underprepared, especially when it comes to business relationships between employer and employee. So, in sitting down and having a conversation and creating an oral agreement, are you going to sit there and go through each little thing? Maybe you're the type of employer who would, but at the end of the day, if you're going to take the time to go through each important thing, much better to have it in writing so that you can very objectively refer to it later. And another thing to consider as an employer, if there is any discrepancy in the oral contract or what has been discussed, the court will almost always side with the employee, because within employment law, there's a recognized power imbalance between employer and employee. And so if there's a term that seems that both parties may have agreed to, but now is in dispute and we're not sure what we're looking at, if there's going to be an agreement with either a term that sides more with an employee, giving an employee more power versus an employer, it's almost always going to be to the benefit of the employee. So as an employer, it's very important to have a contract in place so that you can protect your own, protect all of your own rights within the employment relationship.
Yeah, and just to jump in quickly, the other key point, and Jessica's going to talk about implied terms in a little bit, but even if you don't have a written employment contract, you still have an employment contract. And so Jessica's going to talk about some of those implied terms, but that contract is going to be more employee favorable, and it exists kind of regardless of how much discussion you've had. So setting things out in a written employment contract is very advantageous, and Jessica's going to walk us through a few of those.
Thank you, Victoria. And so going on to the advantages of written contracts directly lead off of the disadvantages, because one of the obvious advantages it will reduce misunderstanding. If it's written there in plain language, it's difficult to mix up words and decide one thing means another thing if it's just plainly written there for both employer and employee to refer to. So this can help parties clarify their promises while the relationship is on positive terms. So another great reason for having a written contract at the onset of the employment relationship, this is when both parties are keen to come together, typically and hopefully. The employee is excited to begin working, and so there's probably more negotiation and eagerness to negotiate on different terms. So it's definitely better to have an employment contract right at the outset. And for example, especially businesses change, people move around, and if you have an employment contract in place, this can provide certainty in situations, for example, if staff changes. So especially in the case of a manager, if you have a manager who, for example, had an oral contract with an employee that they brought on, and then that manager leaves, it would be up to the employee to tell someone in HR or the new manager what the terms of their contract was. And that is clearly not ideal. So because it's, leaving it up to the employee to even remember all of that, I can say that I don't have all of the terms of my employment contract perfectly distilled in my mind. Whether or not that reflects anything on me, I will leave for you to decide, but certainly I like being able to refer to an employment contract, and this can help, especially if there is a change in staff. Your HR manager can simply refer to that contract instead of looking for secondary sources to determine what that is. And also it encourages the parties to address important issues. So as we discussed, there's a lot of different things. Contracts are not one size fits all, and for you and your business, you want tailored clauses that go to protect and consider the different aspects of your business in particular. So oral contracts will miss important terms, which then the court will have the power to imply in the event of a dispute. So it's much better to anticipate problems before they happen and get those solutions to those problems written down clearly in plain language. And having everything written down does force you to think about things as well. So just so many advantages of written contracts, which continues on. And as we've said, advantages provide certainty. So you can read plainly what you've both agreed to. There's a clear record of the terms and conditions. And it's important that these terms are clear so that there isn't a disagreement in what the terms are. It's important to use plain language. So, and provide certainty where the parties are agreeing to terms that are different than normal common law entitlements, such as most likely, and we'll discuss this later on as well, that for Employment Standards Act covered employees, the Employment Standards Act is the bare minimum of entitlements that employees are allowed to seek. So if you are agreeing to anything beyond that, you want to make sure it's in very clear language and that each party knows what exactly the entitlement is above and beyond the Employment Standards Act. Because if something is poorly written, then maybe it could be read to go below the Employment Standards Act. And then we'll also talk about this later as well. You can't contract below below the threshold of what the Employment Standards Act offers employees. So, and then finally, written contracts, they clarify and set expectations clearly. So they allow the employer to exert more control over the employment relationship, because these expectations are in writing. So an employee who comes to you and says, "Oh, well, I don't feel I agree to this. This is outrageous." if it's been considered within your employment contract, you can point to it clearly, point to their signature and say, well, you know, it may have been a few years ago, but you did in fact agree to this. So it just takes out an element of guessing, humming, hawing, and wondering. It's far better to have a written employment contract.
Absolutely. We're obviously a little bit biased as lawyers. We like everything in writing, but there is nothing worse as employer counsel than, oh no, there's no written contract. They've been there 30 years. Here's the positions they've had. And if you're in a termination position, you're now looking at common law notice. The employee is going to have the upper hand. Conversely, if we're acting for employees and they say, yeah, I've been there 30 years and there's no written employment contract, you know, you're realizing, oh, okay, got a lot to work with here. So we're obviously biased, but a plainly written contract is hugely advantageous. We'll talk about this more. They don't need to be long. They don't need to be complex, but having it there is massively helpful for employers. And I'll take it back over to Jess.
Yes, thank you for that. So now we're going to discuss a little bit the interpretation and enforceability of employment contracts. And when we're discussing that, there's a few things to consider regarding the enforceability and interpretation. So the first thing to consider, and this is where employment contracts will sort of differ from your basic business agreement or transaction, because inherently built within the employment contract is a well-recognized understanding that there exists a power imbalance between the employer and the employee. And so in this power imbalance is tried to be protected through the Employment Standards Act. And so you'll see there's lots of legislation that tries to account for that. And also what goes to this is employment contracts are not generally freely negotiated. You have an employee who's coming to you because they want a job, and you as the employer will be dictating the terms more or less of that job, you know, barring any negotiations that may be available to the employee. So it's not two parties with similar resources, with similar means of bargaining power coming in and determining what the relationship will be. It's one person who's seeking income from a person who's able to give them that income, very bare bones terms. And so the power is just not the same. And so employment contracts have implied terms, and this is as we mentioned, so for both employees and employers. And yes, and so the standard implied terms do not need to be written in unless you want to change them. So for example, the baseline common law note, or sorry, the notice provided within the ESA, if you are intending on providing your employee just with common law notice, if they're going to be terminated with cause, you don't necessarily have to write in that ESA entitlement, but it's always a good idea to be very specific with what you're going to be offering your employee in regard to notice and other terms. But in general, those terms will apply whether or not they are mentioned. And so, for example, as we just discussed, certain implied terms, examples of them would be the reasonable notice, whether they're going to have access to the common law notice period or not. Obviously, an employer must provide a safe workplace for employees, and an employer must provide the tools and training necessary for the employee to perform their job. These terms are considered implied because regardless of the terms in employment contract, as I said, these conditions are codified in legislation. Similarly, an employee must give reasonable notice of resignation. So this isn't necessarily specified in legislation such as the ESA, but there is a general implied understanding, particularly for employees that have greater responsibilities and would have sort of similar bargaining power to an employer, such as a CEO or a manager. These people, you're not going to be able to just pick up and leave with a day's notice. That's obviously, that would not be acceptable. There's a lot of things that they need to consider, and they would have greater responsibilities to their employer and or the business. So they would not be able to just pick up and leave. Whereas maybe a lower level employee who hasn't been working there that long, hasn't had that much, hasn't taken on that many responsibilities, their ability to leave, is obviously not desirable. And so, which is another reason why, writing in specifically that an employee should give a certain amount of time in regard to their notice is always beneficial. And similarly, employees have a duty of overarching good faith and loyalty. Obviously, once an employee were to leave, or even while they're employed, they cannot go around defaming the employer, which is covered under the tort of defamation, but is generally implied that, for example, also that when an employee leaves the company, they shouldn't go around spreading personal facts that they learned while working with the employer and or the company. So.
Yeah, and Jessica and I talked about this earlier today as well. In terms of the uniqueness of employment contracts, employment law is actually a subset of contract law, but it's a bit of an awkward one because all of the basic rules around contracts are sort of assuming this commercial contract where it's two parties, equal bargaining power, they're really entering into this agreement, there's back and forth, there's redlining, think of a construction contract. So some of the bits and pieces of contract law don't apply that well to employment law. And that's, Jessica's going to talk about this more in depth in the next section. But definitely there are a lot of sort of important tools that courts have when they're looking at employment contracts to try and sort of correct some of those policies. Now I see Richard's raised his hand.
Thank you very much. So we had a quick question. I will not interrupt more than need be, but great question coming in about recourse that an employer has given a failure by someone to give notice. So an employee who fails to give notice, what do we do? Thank you.
So it's an interesting question because there's sort of the legal answer and then there's the practical answer. So practically speaking, it's rarely worth an employer kind of chasing down an employee for not giving notice. Ideally, you have a written contract that says you have to give X number of weeks notice, and they've technically breached their contract if they don't comply with that. And then the question is, okay, are there damages from that? So if you have a project manager and they leave, no notice, they just leave, and they actually cause financial loss to the company, you do potentially have a claim there. If an employee quits and it's really inconvenient and annoying, that's very frustrating, but in terms of the practicalities of pursuing that, probably not quite as worth it. Obviously, it's best if you have that requirement for notice in the contract, and that's going to, again, depend on the employee. So lower levels employees, 1 to 2 weeks. Senior managers, you can bump that quite a bit up, particularly depending on their role. But yeah, you do have recourse there, and the recourse would be a claim for breach of contract. And then the question is, what are your damages? So I very rarely see, and we very rarely see these going too far because typically there's not a huge dollar amount or financial loss attached, but in some circumstances there can be. And I think employees are sometimes caught off guard by that. But the nice thing about the implied terms is it's not a completely one-way street. I was surprised moving to BC that you don't have to give notice under the employment standards here. Most of the other provinces, I think you do. I'm certainly in Alberta, but definitely you do have recourse, and it would be a lawsuit or starting with a demand letter if they haven't given you appropriate notice, and if it's left you in a bit of a lurch. It also gives you the potential for a counterclaim if there's some sort of wrongful dismissal arising from their departure. They're alleging constructive dismissal, things like that. Jess, anything to add on that?
No, I think you covered it. Thank you.
Okay, and hopefully if you have follow-up questions, just throw those in the chat. But I'll let Jessica take it away with some enforceability issues.
Yeah. So enforceability issues in regard to employment contracts. There are typically 5 main ones, and you'll see them listed here as lack of consideration, unconscionability, obsolescence, violations to the Employment Standards Act, and unclear drafting. So we're going to go through each of these one at a time and discuss the implications. So the first being lack of consideration. We discussed this at the beginning, and consideration being one of the fundamental tenets of a contract being legally valid. So we have to ensure that with each contract that's entered into, there is consideration. And this includes, for example, if new terms or agreement, new terms, or in the case of employment, if new duties are added to an employee's workload, or they're taking on new responsibilities above and beyond what they would have originally signed up for, it's important to get them to sign a new contract stating as such. That contract will require fresh consideration. So whether it's a signing bonus or a raise, something like that, that's required for that new contract to be binding, and for that employee entering their new role with those responsibilities. And something actually Victoria and I were also discussing this morning, for example, if you as an employer do not currently have a written employment contract in place and you want to now introduce one, and you have an employee who's been working with you for 10 years or longer or shorter, that contract will require fresh consideration as well. Employment on its own is not consideration. And so if you want to introduce a contract that lays out all the employee duties and what's going to be the terms of your agreement, that contract, despite probably your relationship with the employee and the employee's duties not changing, if little or at all, that contract will require consideration for the employee to enter into it. So you can decide whether that's a signing bonus or a wage raise, or there are other means as well, but those would be the most common ones.
Yeah, and that's this piece is really important. We do get lots of questions in this area when you're, especially, when a new HR manager comes in, they very appropriately say, oh, there's no written contracts here, we better put some in place. You can definitely do that. You just need to consider, okay, what's the employee getting in exchange? Notice factors in here. This overlaps a bit with constructive dismissal, concerns about changing terms of contracts, but you can give more notice to make contract changes. But really what this point is getting at is you have that employee, they might sign quite happily a new employment contract and really don't have one, right? They may not care. Unfortunately, what happens then is further down the road, if they're terminated and they take that contract to an employment lawyer and they're looking through it and they say, did you get anything for signing this 20 years into your employment? And the answer is no. You now have an enforceability problem that the employee's lawyer is obviously going to leverage to argue that your written contract is not enforceable. So this is an area that's very important. Yeah, there's a good comment here as well about promotions. So these don't need to be cumbersome. You don't necessarily need to have, another full employment agreement. You'll all have dealt with this. Letters are a really common way of doing this. As soon as you have a salary increase, you're sort of giving the employee, yeah, you're getting another X amount of money each year, having that letter confirming the new role, the new compensation, and then an acknowledgement saying the terms and conditions of your previous agreement still apply if they do, or addressing any changes you made in the letter. So again, this is not impossible to overcome. It's just something you want to keep in mind when you're introducing employment contracts, especially for existing employees.
Yeah, for sure, especially if you're taking the time to thoroughly consider and write out an employment contract, to think that would just not be enforceable because you didn't have one key component would be very frustrating. So starting at the basics is always really important, and consideration is very important. So that point, the next factor in considering whether an employment contract is enforceable is whether or not the contract itself was unconscionable. And contracts can be considered unconscionable for a variety of reasons. In general, the unconscionability factor must be sufficiently divergent from the community standards of commercial morality. So the aspect of the contract that's making it unconscionable, it must be something that, if you're to sit back and hear about it, you think, oh my goodness, that's horrible. Like, oh God, that's awful. So some examples would be, it's overly one-sided. So an employer is drafting all these different clauses that address how the employer is going to benefit from the relationship, how the employer is protected from the employee conduct or the employee leaving, and then the contract barely, or if at all, speaks to how the employee will be protected and how what protections and considerations are in place for the employee. Does the employee get benefits? Does the employee have vacation? If none of that is in there, and there's all these lengthy clauses all about the employer and what the employer gets, that might be frowned upon, especially if it's taken to court. Another thing that can make employment agreements unconscionable is if the employee themselves are vulnerable when they sign. So vulnerability can be, it doesn't need to be a long-term state of being. It could just be maybe the person was very unwell or something at the time, that, in the sense that it could take away from their ability to cognate what's going on. A more sort of pertinent example to employment law, if we're working in an industry where literacy, for example, isn't a necessary requirement for the job, we can't assume that the employee is able to read and write at the same level that we are. So making sure that an employee has the time to either have someone explain it to them, and asking outright, do you understand this, or do you need someone to walk you through it? It doesn't need, of course, it doesn't need to be patronizing, and they might want to take it somewhere else that's not for you to necessarily walk them through it, but not assuming that someone's going to understand a contract in the way that maybe you can or we can. Another component to consider is whether there was undue influence when the contract was signed. So if someone was saying, you need to sign this right now, or you're not going to work today, you need to sign this right now, or you're not going to get paid this week, something like that, that would be clearly unconscionable. And the employee was then more or less forced to signing it without any bargaining power whatsoever. And so that would be considered unconscionable as well. And so just a point to reiterate is to make sure that the employee is aware of any of all the terms in the contract, and especially if there's any unusual terms, like terms that go outside of what would be considered regular contract. Like if an employee is required to give a 1 month's notice upon leaving, that's not all employment contracts have that, and as an employer, it's to your benefit to sort of show to them, let's go through this whole thing, and just so you know, if you want to leave employment with us, then we would appreciate if you give, and you're contracted to give 1 month's notice upon signing.
Yeah, we've had a few good questions in the chat that I just want to highlight in terms of, how much time is needed to review. We'll talk about this a bit again in terms of drafting tips, but Richard mentioned usually a week. You can also, you should be dealing with all of these things in your miscellaneous or boilerplate provisions at the end, confirming that they had the opportunity to get independent legal advice on the contract if they wanted. Basically, what you really want to avoid is here's your contract, sign it, and then let's get to work. You want them to have time to review and take it away. It doesn't need to be a huge amount of time. The more complex and high level the position and the longer the contract, the more time they'll need. Mm-hmm. But there's no hard and fast rule about it. But definitely you want to avoid okay, I got this in my contract, I didn't read it, they just said to sign it, so I signed it. So great questions in the chat there on that.
Yes, thank you. And I think I've said this probably 5 times, but I'll say it 6. It's really important to have plain English, plain language drafting in a contract. So even if someone is higher level, reading, very academic, you put a bunch of legalese in there and everybody's going to become a bit confused. So if you can just do it plain, no vague language, that's always to your benefit. Which leads us to the next. Unconscionable consideration in a contract is, sorry, not unconscionable. Yeah, obsolescence. Contracts will not be enforced if they no longer reflect the reality of the relationship between the parties. This is also known as a changed substratum, the changed substratum doctrine, which that's how it's referred to in BC. So essentially, this is touching on the fact that if, for example, you hired an employee as a janitor and they continue to work for you for 10 years and they're brilliant, they make their way up and they become CEO. If that employee is still operating on their 2-page, janitor offer letter contract, that's obviously going to be a problem, and that contract will no longer be enforceable, because clearly the duties and the responsibilities of the job have changed, and these things not only need to be reflected in the contract, but this would also require a great deal more consideration. And so, yeah, need to make sure that that's reflected in a written contract.
That's for those letters we talked about earlier. Formalizing things like promotions and things become very useful because you're basically updating the employment relationship as you move along, rather than having those big gaps between your initial contract and your final contract.
Yeah. And on to compliance with the Employment Standards Act. I think I mentioned this before. The Employment Standards Act operates as the bare minimum of how an employer-employee relationship should function in a variety of ways. And so to ensure compliance with changes in legislation, contracts should provide the greater of the contract benefits or statutory benefits. So if you're worried you're going to be in conflict, it's always a safe bet to provide more than what the Employment Standards Act offers, especially because legislation does change and you don't want to have a clause in your employment agreement that could eventually or would now be in contradiction with the Employment Standards Act, because then it would be automatically void and unenforceable. So another great reason to review employment contracts and the legislation regularly to ensure they are both in alignment. And if you're unsure of how to do that, then Ascent employment law is also wonderful at keeping people up to date with that. Or yeah, perfect.
This one's now more important than ever. There was a decision out of Ontario last year, the year before, called Waxdale, and it made the collective employment employer council bar gasp. It caused a lot of angst because it was essentially a case where there was a termination provision in a contract. There were two parts to it. So there was without notice termination piece, or sorry, without cause, and then a for cause piece. Not uncommon, right, to have those separated out. This particular employee was terminated without cause. So the employer was relying on their without cause termination provision to say, we only have to pay the minimum standards. The employee argued that because the just cause section of the termination provision was offside employment standards, so in Ontario, their act actually deals with some entitlements on a cause termination as well. So this provision was offside of that. The court actually threw out the whole contract, that whole termination provision. So even though there was nothing wrong with the drafting of the without cause section, they weren't entitled to rely on it because of that issue with the for cause. And so we'll talk about severability provisions when we talk about boilerplate language. Those are supposed to be your saving, oh, okay, this provision was wrong, but you can cut it out of the contract, tape it back together, and we can rely on the rest. And the court refused to do that in this case, basically saying, nope, if you contracted or tried to contract out of employment standards, you're out of luck. So it's really important. And this is why we like language, like Jessica said, with the greater of, or catch like a saving provision in your contract that says if anything's non-compliant, assume it is. That's an Ontario decision, and BC courts sometimes follow that trend. So nothing right on point like that here, but certainly something that raised some red flags for us and caused us to tighten up our termination provisions. Yeah. Oh, I have one more point on this Employment Standards Act that we talked about this morning. Oh, if I agree, Jessica, if I agree that I'm willing to do something less than employment standards, or I want to contract out of something, are we able to do that? Contracting parties, can I sign an employment contract with you?
No, you cannot. So just because the employee would say, oh, well, I'm okay with the fact that it's not, that this is goes against Employment Standards Act, it's like, well, that's fine, but it still doesn't, it's still not enforceable. So Good try. Which lends nicely into the last slide in regard to this topic, which is ambiguous language. So ambiguous language in contracts is a very risky and potentially problematic aspect of employment contracts. So, for example, the courts can interpret contracts against the drafter. And the drafter typically in this situation will almost always be the employer. I feel like there probably are some examples of employees who have a hand in drafting their employment contracts, but typically you, the employer, will be the drafter. And so the courts are going to interpret the contract against you if there is vague language in favor of the employee. So it also risks employee understanding. So if you have some vague term in there discussing employee benefits or duties, and the employee comes to you and says, oh, well, I've been doing it this way because it says this in the contract. And then you realize that, oh, it could be read that way. That's a potential danger. And it just, you can alleviate all of these potential stresses by having very clear language in regard to everything that's put within the employment contract. And this also goes to what Victoria was talking about in regard to boilerplate language. There's a real danger in just taking something off of, and I've definitely seen this as well, taking Google template contract language and thinking, aha, this is perfect. I've drafted a contract. And I mean, I'm sure there are some aspects of that that might be okay, but in general, for businesses and employees and employers, one size does not fit all. And it's important to go through the contract thoroughly and make sure that you're aware of every single clause within there and that it actually applies and how it's going to function. And depending on how it's written, you know, a few words can drastically change the implications of how the relationship can work itself out. So, for example, severance limiting clauses within termination, if you as an employer want to make sure that your employee is only going to be able to seek severance damages in line with the Employment Standards Act, which the maximum of which is 8 weeks, and you want to make sure that they cannot also claim common law damages on top of that, you have to lay that out very, very clearly. Even the slightest bit of ambiguity, and then the employee will be able to seek common law damages. So if you want to do that, it really helps to have a lawyer draft that for you as well, because I find that that the clauses and what courts specifically consider to be clear language can change, and it is within case law. So if you find yourself case law savvy, then there are cases that discuss this, but the differences in a few words can drastically have implications on what an employee can be entitled to at the end of a relationship and in regard to other employer-employee relationship, even while the relationship is still ongoing. So having plain, clear English to outline what is going on, how you're going to be relating to one another is extremely important, so that there's no discrepancies in mind, and that if disputes do come about, it's very easy to see what the intentions are and what the solution is upon that dispute coming to light. So I believe that ends for the Contracts 101, basics of contracts, and now Victoria is going to lead us through key contract terms in employment contracts and which terms you should consider having.
Yes, and I see Mr. Johnson has his hand up. Reveal yourself, Richard, and share with us your question.
I do. Zita had a great question. Just as we're talking about clarity and transparency, sometimes the employment standards legislation updates. Like January 1st, we saw that sick leave got announced in BC, so people get up to 5 days of paid leave and 3 unpaid days. What do we do with that in terms of, you know, introducing a new contract, a letter of acknowledgement? What do you recommend in that vein?
Yeah, you can stay visible, Richard. Might get you to weigh in as well. So we have seen lots of questions on this. It depends a little bit how your contract deals with this. So when we have clients who work in multiple provinces, I actually recommend keeping your language pretty general when it comes to kind of the basics, right? So if your plan is to provide people with the employment standards minimums for vacation, for example, you can just say that that's what employees are entitled to. You're entitled to vacation pursuant to the applicable employment standards legislation in your jurisdiction. Yeah. If you want to have it general, you can also be more specific. Now, if you already dealt with sick leave or you had paid sick leave, you'll want to make sure that's still compliant. So if you provided, for example, in your contract for 2 paid days, you know, that you're now going to need to update, you can do that by way of a letter, just confirming, or a policy saying everyone gets sick, you know, regardless of what it says in your contract, everyone is entitled to this additional paid sick leave. So there's a couple different ways depending on your existing infrastructure. I know Richard's also been giving lots of advice on this, so I'm going to let him weigh in with any other tips he has for dealing with that.
Yeah, thanks, Victoria. And I come at this from 2 different angles. The first angle is a legal technicality, and that is that if you have somebody coming to the court who says, I'm suing for wrongful dismissal. I've been dismissed and I think I'm entitled to a bunch of severance. Also, I didn't get my overtime. The court can dismiss that claim for overtime unless it's imported into the contract. So we always want to be careful because the courts don't have jurisdiction over stuff that's in employment standards and arises only because of employment standards. A case called Macareg Care tells us that if there's a mechanism in the employment standards legislation that allows people to seek those statutory entitlements, they got to go there first. And usually it's a shorter window to do that. So it's helpful for us as employers. It's a 6-month window here in BC. And so the more you import into the contract that touches on employment standards, the more you're open to saying that becomes a contractual claim and people can pursue that as part of a court claim. So bit of a technical aspect there, but I would generally say, just like Victoria mentioned, the less said about statutory entitlements, the better. But what I do think will come up, and it's useful to flesh this out, is employees don't know that those 5 paid sick days are included in any existing sick time that you've already been offering them as good employers. So that's a point of clarity that can sometimes be dealt with through a policy or a letter to employees, just to flesh it out.
Yeah, even an all employee message confirming, you know, you already get 10 paid sick days, or you have unlimited sick days that are paid.
Yeah,
like,
we're already great. We're just going to continue to be great.
Yeah. And that's usually, I like to include that language for most of our clients saying, we give you above and beyond employment standards. And if there's any case where we haven't, obviously the minimums apply. But yeah, exactly what Richard said. You don't need to get super specific. I'll talk about this a bit too, but for example, leave provisions, those are a bit fiddly because they vary between province. They change the requirements sometimes for them. So you don't really want to be in a position of having to incorporate all of that language around unpaid leaves into your contract. It's already an employment standards legislation. So you don't need to deal with it unless you're doing something different. And by different, I mean better, because you can't do something worse. So great question though. And please keep the questions coming. They're really informative and we want to make this as useful for you as we can. So Jessica might leap in on my section as well, like I did with hers. But I'm going to switch gears a little bit to talk about key contract terms. Now, contracts are not one size fits all. You know, hiring an executive for a tech company, that contract's going to look different than a salesperson or a receptionist or a retail worker. So you need to adjust your drafting to make sure that you're kind of making it make sense for you. So you don't need a 15-page agreement. Longer is not necessarily better. What Richard was talking about is a perfect example of where less can sometimes be more. And again, the plain language piece means that you can have pretty concise. Many of you will have, you know, 1 or 2-page offer letters, for example, 5 pages. If you're into an executive contract, there might be 10 pages, and then you might get into equity compensation, and those become more complex, but certainly that's not necessary for every type of contract. The other thing is they vary between industries. So sometimes you'll see industry-specific terms that employees expect to see. So I'm not going to exhaustively cover, this is exactly what we put in an employment contract, because that's going to take a lot of time. And many of you already know that, but I am going to cover some of kind of the highlights, but I'm also going to talk about those boilerplate provisions or miscellaneous. Sometimes they're called general, so things like choice of law, entire agreement, severability. This is a pet peeve of mine because I think people gloss over those, and they're actually really important. So we'll talk about why they're important as well. So I'm just going to double check the chat for any questions. Oh, nope, just thank you. So in terms of the basics, start date, when is the employee starting? This is also useful. So in the case where you're introducing a written contract for the first time, for example, you're going to want to deal with continuous employment. So when's the start date recognized, right? Does that employee have 10 years of service? Or is it starting from the current day? Typically, you would be recognizing those 4 years of service. The term of the contract, most employment contracts are indefinite term. And so that means it's in place until one of you decides to end it in accordance with the agreement. So you can terminate their employment, they can resign. You can also have term contracts that have a fixed end date. Now, if you have a fixed end date, so I'm supposed to work for Ascent from today until December 31st, 2022. December 31st, 2022, I'm done. I know I'm done. There's no entitlements beyond that. I move on. They can be a bit problematic though, because if we're 6 months into the 12-month contract and Richard's like, oh, you know, Victoria's a little annoying to work with. She talks a lot. She's really opinionated. This isn't working out. and he wants to let me go. He's going to have to pay out the whole 12 months unless the contract deals with terminating early. And unless the contract deals with mitigation, I also don't have any obligation to look for work. So there's been some cases in the past couple of years where employers have got really caught out with this. So term contracts, use with caution. The other problem that sometimes comes up is if you keep renewing year after year, a court's going to say, oh, we think this was probably actually meant to be an indefinite term. Or if you forget to renew, it's going to convert over to an indefinite term. So you can definitely use them. They're very appropriate, obviously, for like project-based or, you know, mat leave coverage, things like that. Very appropriate. Make sure you address termination and just use with a bit of caution. Job description. This is, again, just clarifying your expectations. I like to attach these as a schedule because it's a bit tidier. You don't need to. Responsibilities, and then also building in some language around you as the employer having the ability to modify those duties. And this is kind of getting at avoiding constructive dismissal claims. Obviously, you can't, there's no language that's going to let you demote someone from president to absolute bottom of your corporate org chart. But you can certainly build in language that makes it obvious, hey, we can exercise our discretion reasonably to kind of tweak your job duties as our company needs change. Perfectly fine, perfectly allowable. Other key terms, remuneration. This is obviously from an employee's perspective, super important to set out. So you want to include these things: vacation, benefits, bonus commission, stock options. Depending on how complex the compensation scheme is, there might be separate agreements that apply. I'm not going to get too into detail in terms of language around bonus and equity plans, but these are, again, a bit of a tricky area. Many of you may have heard of the Supreme Court of Canada decision, Matthews and Ocean Nutrition. This company got hit with the $1 million+ payment out to an employee who left constructive dismissal under a long-term incentive plan. And the court reiterated what's always been the law, but if you have a notice period and it's 12 months, your employee is entitled to everything they would have got as if they'd stayed employed during those 12 months, unless your contract says otherwise. And Oceans and Nutrition, the court put a pretty high standard on how excruciatingly clear you have to be in equity plans to actually contract out of that common law. So if this is a big portion of an employee's compensation, so executives again, for example, you are going to want to turn your mind to what happens when an employee is terminated. Are they going to be entitled to their bonus or not? And you can deal with that in your contract proactively, because that's something that is a gray area, so often fodder for legal disputes. But again, you can proactively deal with that. Anything else you provide your employee, vehicle allowance, professional development can be another good one to include, especially if you want any of those amounts paid back if the employee leaves after a certain time. Again, something you can do, but you want to make sure it is included in your contract. Hello, Richard.
Thank you. So another question that came up, it's a really good one that I just want to put on the radar. What do you do in terms of covering off changes to policies and procedures? And if I could paraphrase this a bit, what's the bright line between a term of employment and a policy and procedural change? And how do we deal with that? Not to put you on the spot.
Yeah, that's
an easy question, right?
It's a great question. I don't know that it's a super crystal clear answer. You can actually specifically deal with your hierarchy of enforcement in your contract. So you can say, all right, number one, terms of the employment contract govern. So if there's a conflict between a policy and the employment contract, your employment contract governs. And you can also incorporate your policies by reference, or you can and we recommend having something that says you, employee Y, are required to comply with all of the company policies as they may be in place from time to time and amended. Hopefully a little more articulately than that in the contract, but you can deal with that directly in your contract by saying, we have policies, they might change. This kind of goes back to changing anything in the employment relationship, where if you can give notice, that's ideal. Make sure people know there's a change. Policies, it's a bit of a fine line how much you want to incorporate them into the contract, but you definitely, so for example, your just cause section, if you have a just cause provision, you can reference that breaches of your policies are going to be considered to constitute or may constitute just cause, depending on the circumstances. But in terms of changes, usually you can have one simple provision that deals with policies. You're expected to comply. We can change them. We'll give you notice of those changes. You have to comply with the changed policy. Again, this isn't going to cover you off if you do something really extreme, like change so that everyone, no one has, well, can I even do that? Yeah. So if you're making normal changes, you're going to be covered off by including that language in your contract. Richard, does that answer the question fully?
I think it does, yeah. And I mean, I completely, just for what it's worth, align with that in terms of those situations where an employer might try to change severance terms by a policy. Like everyone will go from common law to employment standards by policy. I don't think any of us at this in this panel would agree with that. So
no, and I generally say don't talk about termination in your policies. Policies are for things like your dress code. How do you submit expenses? What are our paid time off and leave policies, and how do those work? Those are the logistical, procedural things. When it comes to like the really key terms of a particular employee's employment, like termination, you definitely want to have those in the contract. And we'll talk about this as a drafting tip, but it's also a great question because you want to make sure they're consistent as much as you can. So if you have a really big handbook and a ton of employees, or you practice in a lot of jurisdictions, that can get difficult. But that's where kind of parsing out, you're not going to talk about your dress code in your contract. You are going to talk about that in a policy.
Right.
And then there's also a distinction between, and this relates to the bonus piece. So there would be a distinction between, for example, Schedule A of an employment contract. That's actually a stock option agreement, for example. The stock option agreement is a separate, standalone contractual agreement. Policies are not contracts, usually. So that can get a bit tricky, but if you have an employee handbook or something that's called a policy, it's not intended to be a contract. So the other piece too, if we go all the way back to the basics of contracts, you also have the intention you need to have an intention to create a contractual legal obligation on someone. So that's where, you know, if I tell my neighbor, yeah, absolutely, I'll shovel your driveway. If you look after my dog and they look after my dog and I don't shovel their driveway, they can't sue me for breach of contract because that's not intended to be a contractual relationship. So policies, I think it's fairly clear that the intent there is these are guidelines. These apply, they're being imposed by you as an employer. They're definitely not being negotiated. So they do stand alone separately from the contract.
Thanks very much. Great question, great answers.
Yeah, no, great question. We love the questions. Yeah, and in terms of, I definitely am not going to get into equity agreements because they're really technical, but if you have those are separate agreements completely. So key terms, paid time off, depending, obviously, if you're more generous than employment standards, you're going to include that. If it increases after a certain period of time, reference that. Like we said, leaves, we actually prefer not to include in the contract. Right to disconnect, this is probably more accurately a policy. This I mostly included because I'm excited about it. So Ontario just made this a requirement for employers to have a right to disconnect policy in place. So just highlighting that as something that BC may also eventually decide is a requirement. Probationary period, this is important mostly where you want to do something other than default. So you have the 3-month probationary period that exists in the legislation. In some cases, it's appropriate to extend that. For example, professional employees, 6 months is not uncommon. You can do that, but you want to specify that in your contract. I occasionally have seen some as long as 12 months. I've never seen anything longer than that because I think you'd be running into some fairness questions there. But certainly if you're going to, where you want a longer probationary period, include that in your contract. Similarly, anything like relocation, so you know that you're going to want employees to be able to move around or travel, if travel is a requirement. Those are great things to include in your contract because you're basically closing the door on the employee later saying, what do you mean I have to travel to Florida for this conference? And this is omitting COVID considerations for now. You want to have that in your contract so that it's clear from the outset. This is an expectation of your employment. You knew that when you signed on. This isn't constructive dismissal. This is just part of your job. So good to include language on that. Intellectual property. This is very employer specific. For some employers, this is hugely important. And you'll want an IP lawyer to be weighing in on those provisions. For others, you can kind of do the basic coverage for IP, and that's fine. And in some cases, that might not be necessary at all. So termination, this is the big one. So as you all know, common law notice can be a really significant liability for employers when you're dealing with a long-term employee. As Jessica's already talked about, you cannot have a termination provision that falls below employment standards. And that means at any point in time. So even if at the time this becomes an issue, it's technically compliant. If it's drafted in such a way that 5 years from now it wouldn't be, you're still out of luck. It's still not going to be enforced. But you can replace the common law notice with a different amount of notice or pay in lieu, and you can set lots of parameters around how you want that structured. So I've seen executive contracts that specify exactly what happens with the bonus, what else is included. You can be detailed if you need to. Most, if you're wanting to put it to ESA minimums, a clear, simple provision that says that's what you're doing, and that's what the employee gets. It's absolutely should be enforceable, subject to what we've already talked about. We're lucky in BC. I think courts take a very reasonable approach to this. Ontario courts have been super creative in overturning termination provisions. But BC, if it's clearly drafted, it's probably going to be enforced. It's a good practice to have that particular clause perhaps initialed by the employee or have every page of the contract initialed, just so it's drawn to their attention. Again, you don't want to hide this. So you don't want to put it in a policy. You don't want to put in smaller font or attach it to the end. Very obvious that the employee saw it, they read it, they understood it, and they agreed to it. And again, we talked about just cause. You want to include language saying that anything considered just cause normally is obviously just cause, but then you can add some specific language. And this is especially useful, again, for kind of higher level employees where there's this real increased amount of trust as well. Inducement. So this is fairly rare, but if, for example, you have an employee, they're very senior, you headhunted them really aggressively from another company, they agreed to come over to you, they left secure employment, and they are now working for you. If you terminate them within a year or so of hiring them, they might have an argument that they're actually entitled to a longer notice period because they left secure employment. So you can proactively deal with that in your contract and specifically reference it just to kind of remove that argument for that particular employee. But again, that's not super common. So I know most of you have lots of familiarity with termination provisions. So unless I see Richard's hand go up for questions on this, I'm going to skip over to our next topic, which would be restrictive covenants. So I don't know why I like these so much because they're not actually really super enforceable for the most part. So a restrictive covenant is basically anything that's going to apply to the employment relationship after it ends. So post-employment restrictions on what an employee can do. You can put them in place, definitely. Confidentiality are the most common. Most employers are going to want this. How important it is and how detailed it is, again, depends on the employer and your needs. But they are certainly something you can include. There's an implied duty of confidentiality, like Jess said, so that exists anyways, but it's nice to really solidify that. And it means when you do your termination letter, you can reference back to this and say, hey, remember when you signed your employment contract and you agreed post-termination, you won't be disclosing any of our secrets to anyone. You still have to do that. So these are usually recommended for most employers, unless it's really not a concern. These latter two, non-solicit and non-compete. So non-solicitation, you can have these be enforceable. So you can put them in place, and if they're necessary. So if you have an employee, they're a developer, they sit on their computer, your clients wouldn't know them. They're a nameless person in your organization from a client perspective. You don't really need a non-solicit because they have no relationship with anyone that you deal with. If you have a salesperson, that's quite different, right? Anyone who's kind of the face of the company, they have lots of contact with their clients. If they leave, there is a risk that people will go over to them if they actively solicit. So you can have non-solicitation clauses. You want those to be limited in time, 6 months to a year. Ideally, if you can match your non-solicit with the notice you're giving, that's always nice, but not necessary. But certainly non-solicits are things you can include. Non-competes are presumptively unenforceable because they're a restraint on trade. There's also public policy reasons for it. Obviously, if I'm signing a non-compete saying I'm not going to practice law in BC, if I want to keep working as a lawyer, I have to move provinces. That's pretty extreme, and that would be pretty unreasonable for me to agree to. So probably not going to be enforced. So non-competition clauses, Ontario just passed legislation actually making these illegal to include in contracts. And BC, I wouldn't be surprised if they follow suit in the next couple of years. So they were already really hard to enforce. They may in fact become not possible to include. I have seen non-compete clauses used appropriately. So for example, an owner of a company, there's two owners, one of them leaves. They've agreed that they're not going to open a competing business for a period of time. And they're also usually getting paid out a large sum of money in exchange for that. So those are kind of unique circumstances. For most employees, a non-compete clause is not permissible. The other interesting piece of the non-compete clauses is there are things that tend to be worded really, whatever the opposite of plain language is. They're not quite in Latin, but they're pretty bad. So I have an example of one, I'm sure drafted by a lawyer. So this is from a case with an optometrist. And in the optometrist's contract, they said the optometrist hereby covenants and agrees that during the term of this agreement, for a period of 3 years from the date this agreement is terminated, the optometrist will not compete either directly or in partnership or in conjunction with any persons or persons, firm, association, syndicate, company, or corporation, directly or indirectly carry on or be engaged in, etc. If I'm having to take huge deep breaths reading your contract provision, those words, this actually worked against this employer. So this was not found enforceable because the court was like, what does this mean? What does this mean? So it's not, I think sometimes, and I blame some of our colleagues in the legal profession for this, there's no magic to contracts. You're literally setting out the agreement between parties. So using overly complex language or heretofores or multiple qualifiers, it's important to be comprehensive, yes, but you don't need to make that really confusing or frustrating. And that was not enforced by the court, largely for those reasons. So that's my soapbox. I will move on.
I can jump in as well and say,
yeah.
like, one of the main reasons non-competes are not enforceable and have been made non-enforceable in Ontario is this recognized power imbalance between employer and versus employee. So as Victoria mentioned, when non-competes are actually enforceable is typically because the employer-employee or either non-employer-employee, it was two managers, or they have more equal bargaining power and more opportunity to potentially impede the business, where as an employee who's worked for an employer for several years within the same industry, their employment experience is limited to that. And so to ask them to not go somewhere and benefit another employer in a similar business, well, you're sort of cutting their legs out from underneath them, in that the majority of their work experience comes from working and spending time within that specific business. So that's another, the difficulty of the language also sort of points to this power imbalance, that you can use these heretofores and Latin whatever, and I think that's why courts overall are not, and I think Victoria mentioned, we're pretty sure that BC may follow suit with not enforcing the non-competes altogether, just because it typically is going to benefit this already intense power imbalance that we can see within employment law. So
yeah,
I appreciate your soapbox.
Great point. Thanks, Tess. So I hope you didn't think we got through an entire presentation without mentioning COVID-19. I had actually had hopes for that, and then David said that he'd let everyone know we'd be talking about additional terms. It's a great idea. I'm happy to talk about it. Really, COVID-19 has not drastically changed the world of employment contracts. So there's no huge unprecedented, oh my gosh, we have to redo everything. But there are a few, of course, COVID-specific considerations that we have seen. So vaccination requirements, I've seen this quite commonly in contracts now. Part of your precondition of your employment is that you're fully vaccinated. The language on this has been the source of a lot of conversation amongst the team, because you want it drafted in a way that's going to cover off kind of boosters as things get recommended. And so we're trying to be, as much as we can, look into the future and say, okay, what's going to make sense longer term to include in contracts? But you absolutely can include vaccination requirements as part of an employment condition. You have to bear in mind human rights accommodations here, just like you do with any sort of vaccination policy. But we do have language on that. So if it's something that's important to include, especially if you have employees interacting with the public, you help seniors, work with vulnerable populations, for example, all great examples where it's very appropriate to have vaccination requirements actually specifically included in your contract. Or to go back to the question, if you have a vaccine policy, you can reference that directly in the employment contract. And again, emphasizing this is a requirement of your job. Full stop. Temporary layoff. So this is something that was not always included in contracts. With COVID, its importance suddenly had a huge spotlight put on it. So the issue with temporary layoffs is if you don't have anything in your contract, an employee can argue that they've been constructively dismissed, they're temporarily laid off. And that's because going to work and getting paid is obviously a key term of your employment. So suddenly being laid off, your employees do have an argument around constructive dismissal unless they consented to it. And obviously COVID was unique. So how that plays out is not quite the same as just randomly laying somebody off for other reasons like operational requirements. But if you include a temporary layoff, and again, this is like a one sentence clause, just saying you understand and agree that we have the ability to temporarily lay you off for business reasons, subject to requirements of the Employment Standards Act. Something that simple is going to cover you off. Remote work and hybrid work arrangements are the other pieces. Again, these are often policies as well, or you can have separate remote work agreements. But when you're bringing on new employees, it's going to be important to them to know, is this fully remote? Is it hybrid? If it's hybrid, what's the expectation in terms of being in the office? So these are definitely good terms to include. If not in the contract, have a policy or separate work arrangement. The other thing that can come up is your home office costs. So who pays for what? When you're talking about employees working from home, who owns equipment? If there's security considerations, for example, do you have a shredder? How are you dealing with members of your household wandering through your shared space? Those are all things, again, that you can deal with either through policy or an employee-specific agreement attached, or you can include some language in the contract. The main one I would say is for remote work and a right to recall to work. So if you want the ability to have your employees come into the office, or if you have team meetings, build in that language directly into your employment. And again, this is partially just being transparent with employees, and it's going to stop it doesn't say in my contract I have to come to work. I thought this was totally remote. I'm not going. You want to try and get ahead of those arguments as much as possible, as I think hybrid work arrangements become, I don't want to say the norm, but much more common than pre-pandemic. So boilerplate terms. So these are the sections I said that tend to get glossed over when you're finishing up your employment contract. These are also often worded in really complex, non-plain language. They don't need to be, they're all fairly straightforward. So we talked about inducement, independent legal advice. This would be the clause that says you had the opportunity to go talk to a lawyer if you wanted, and you either did so or you waived your ability to do so before signing. Again, it can be worded simply. You can't put that in there if you don't give the employee that opportunity, but as long as they've had sufficient time, you can assume they'll ask you if they're actually getting legal advice on it. Hey, I can't talk to the employer until next week. Can I have an extension? That would presumably happen. Entire agreement clauses, cognizant of our time here, but there's a really interesting case with entire agreement clauses out of Ontario. And this was with Herbal Magic Inc. So I always think of the Herbal Essences commercials when I think of this case, but it's nothing to do with shampoo. So a senior executive signed on to a contract with the company being bought out. And he signed on with all this like shiny promises by the person buying out the company. So we're going to make you president and CEO. You'll be here a long time. You'll be key in the development of the company, et cetera, et cetera. This guy invests $2.5 million in this new company, and he is made president and CEO, but then he's fired really shortly after. And so he tried to sue for negligent misrepresentation. So basically, and a collateral agreement. So basically, I know it doesn't say anything about this in my employment contract, but I was told all of this stuff when I signed on. And the company was only saved by the fact that there was an entire agreement clause that the court found was fatal to the claim, because it very clearly said, nope, no matter what you've been told, who you talked to, what was said, we're relying on the entire agreement provision. Now, this was one where you had quite an equality of bargaining power. So I don't know, in today's climate, I think a court would be looking for ways to rely or to get around it if they could. But it's definitely a really important clause to have, especially if you have a hiring process that involves lots of different people and lots of different conversations. So you don't necessarily know what this employee was told in terms of what their job was going to be like. Incorporation policies, this is going back to the great question. Yeah, you can definitely incorporate those in choice of law. Again, if you're a multi-jurisdictional employer, it's important to say the law in BC applies. Severability, if something here is wrong, it doesn't invalidate the rest of the contract. Oh, we have independent legal advice twice. But essentially, these are important. A few contract drafting reminders. We're getting through to a close. So consistency is important, and that's not just within the contract, but like I mentioned earlier, between your policies. So being consistent, trying to avoid contradictions where you can. You, the employer, should know what all of the terms mean and why they're included. So it's great to get a legal contract or a template employment contract from lawyers, for example. That's really important. But if there's a term in there that you don't know what it means, or you don't think it should apply or be included, definitely discuss that with us, because that's important. I guess in terms of general or catch-all language, that's kind of back to those saving provisions, or being a little less specific sometimes to avoid having to update all the time. There should not be any Latin in your contract. Heretofore, it doesn't improve its legal enforceability. There's no magic there. The pinch of pessimism, this is a very lawyerly view, but I think a little bit of employment contracts, like a prenup, you don't think your marriage is going to go sideways. You want it to work out, but you know that it might not, and you're putting protections in place. So employment contracts can be drafted, and this is again very lawyer comment, with a little bit of pessimism. What if things don't work out? How can this be misinterpreted? You want to be careful there. So in terms of best practices, give employees time to review the contract. No magic number. I think we usually do a week. If you more time's better. And again, the more complex the contract, the more time you want to give them to review it. Make sure it's signed before the employee starts working, or you run into a really weird technical argument around, again, fresh consideration. And none of this applies to me because I worked before I got this. So best practice, just make sure it's signed and agreed to before they start working. Any special promises or considerations or things that are unique, put them in the contract. And again, termination clauses require special attention, as do any post-employment obligations. And I'd add that termination includes what happens with things like bonuses or commission payments when you're let go, because those can become contentious. You want to deal with those proactively. And again, this just goes back to the fresh consideration piece, but if you're implementing a contract or adding contracts, it's a great idea to do so. You just need to be a bit careful with how you go about that. So that takes us to the end of our presentation. Thanks so much, all of you, for sticking around. If people have any additional questions, we'll leave things open for the next 5 minutes. I feel like Richard might have some planted seeds of insight, but otherwise, if you need to log off, we'll make the recording available. We'll send out slides. We love talking about contracts. So if you have questions or want to review them, I find them super interesting. I'm a huge nerd, freely admit that, but it's definitely an area of work I love. And there's such great tools to avoid legal costs, etc. So any additional questions, throw them in the chat. If you need to log off, absolutely feel free. Thank you so much for joining us today. We really appreciate you sharing your valuable time. Just anything to add before we sign off?
Nope, that's great. Thank you so much.
Amazing, thanks. So we will leave it open for questions. Richard, is there anything you're dying to add? Lurking.
Great questions. It's just these are developing issues, and as much as contract law goes back centuries, we are here to keep up to date on things and provide the applicable side of things. So we want to make it as practical as possible for people. So please do give us your questions, touch base with us, let us know how you can help. And yeah, thanks for the information, you two.
Yeah, and to everyone still here, if you have ideas for future employer huddles, let us know. We're looking at doing one on COVID-19, shaking our crystal ball into the future of what that all looks like. And we have a few other topics in mind, but if there's anything you'd love us to dive into, please let one of us know. Like Richard said, we want to make these as useful as possible for you. And so any burning issues on your end, we'd love to hear about them. All right.
Thanks very much.